So you've got a contract, right? Everything looks perfect, all signed and sealed. But what about that handshake promise? You know, the one you made right before putting pen to paper? Does that actually count for anything in court? Today, we're going to untangle that very tension between the written word and a verbal agreement.
Okay, picture this for a second. A massive shipping deal, all planned out. There's a formal written contract, and then there's a crucial verbal promise for some extra safety. And then, disaster. A very, very expensive splash right in the middle of the ocean.
All right, let's dive into this, because this isn't just some hypothetical story. This is a real-life case, J. Evans & Sons, from back in 1976, and it is the perfect illustration of this clash between what's written down and what's said out loud. So here's the breakdown of what happened. J. Evans & Sons had a deal to ship some machine parts. Now, the written contract had this kind of vague clause in it, basically giving the transporters free rein on how to handle the goods. But, and this is the really important part, they also made a separate verbal agreement to keep the goods safely stored below deck. Well, you can probably guess what happened. The container was shipped on the deck, it fell overboard, and was lost to the sea.
And that leaves us with our central problem. The written contract didn't get specific on how to ship things, but that verbal promise, oh, it was crystal clear, and it was broken. So the huge question for the court was, who's on the hook for all that lost cargo?
To answer that, we have to zoom out from this one story and really understand the law's default setting. When a court is looking at a written document and a totally different verbal story, where does it even begin?
Well, the starting point for pretty much any court is this basic idea. The written contract is the entire agreement, the whole shebang. The law does this to avoid what you might call lunacy, a world where after any deal goes south, anyone could just claim, oh, but we also agreed to this other thing. It would be chaos. This really gets to the heart of the whole principle. The default view is that, quote, the writing that exists is the all-encompassing beginning and the end of the contract. I mean, that's a pretty powerful stance that gives a ton of weight to the written document.
And this powerful idea has a formal name. It might sound a bit complicated, but it's absolutely central to contract law. It's known as the Parol evidence rule.
So what the heck is it? Well, parole is just an old-fashioned word for oral or spoken. The rule basically says that any evidence from outside the final written document, like that promise to ship below deck, is probably inadmissible in a dispute. The idea is that the contract is supposed to speak for itself from within its four corners.
Okay, so based on that rule, it sounds like J. Evans & Sons are pretty much out of luck, right? The verbal promise should just get tossed out. Well, not so fast. Let's talk about the loopholes.
And this is where it gets really interesting, because we have a direct conflict. The Parol evidence rule says the verbal promise is inadmissible, but in the J. Evans case, the court said the exact opposite, that the promise was a valid part of the contract. So what happened? How did they get there?
The court didn't just apply the rule like a robot. Instead, it took what the source calls a holistic view of things. It looked at all the circumstances surrounding the deal, their business history, what was normal in the industry, and decided that both parties truly intended for that below-deck promise to be part of the deal. So they treated the whole thing as an exception.
And the J. Evans case wasn't some wild one-off. The Parol evidence rule has several well-known exceptions. For example, you can use outside evidence to fix a clear mistake or a typo in the contract. You can also use it to fill in the gaps when a contract is totally silent on an issue, or even to figure out when a contract was supposed to officially start.
So knowing the rule and its exceptions is pretty fascinating, but what's the practical takeaway here? I mean, how do you make all this work for you in the real world?
It all really comes down to one single golden rule. If a detail is truly important to you, get it in writing, period. Because while courts can and do make exceptions, you never want to be in a position where you're just hoping a judge will find one for you. That written document is your strongest protection, always.
So the Parol evidence rule treats a contract like a sealed box, where everything important is supposed to be safely locked inside. But that leaves us with one final, fascinating question to chew on. What happens if the reason something wasn't included is because you were tricked or misled into sealing that box in the first place?